let's switch gears sort of dramatically for a moment. Congress 3 years ago was considering legislation that would have imposed major constraints on very large platforms, on limiting their ability to make acquisitions, things of that sort. And now you'd say AI is the news everywhere. There's an executive order on AI. All the people on the Hill are concerned. Barry, what do you hear about the primary concerns in Congress about AI and potential competitive abuses? Does anyone, should they have investigative hearings? Are they going to do that? Does legislation make any sense here? And then what about state initiatives to regulate AI? We haven't talked about it, but state antitrust laws exist in parallel to federal. Supreme Court said that's fine. And a number of major state antitrust laws, like California and New York, for example, are much stricter than they impose greater constraints than federal antitrust law, so there's a certain, you also have to worry about, as a counselor, about that. And then there's Europe. We already mentioned Europe. Maybe we'll mention it a little bit more. A big, complicated mess of regulators ready to pounce. So does anyone have thoughts on that, Barry? Or you saw these?
So,
yeah.
I mean, there are a couple cases in California against OpenAI under the California Unfair Competition Act. And I think there, in the motion to dismiss, which was denied, the court said that even though the conduct's not unlawful, it may still be unfair. And so that, that standard is pretty broad. And that was a case where some authors were suing because I think it was ChatGPT was sort of using their work to create summaries or something of that nature. So there are state laws that, and arguably the FTC Act, that can take a very broad view as to what constitutes a problem in the AI sphere. With respect to legislation, I think, I'm not a lobbyist. I'm practiced before the agencies, so this is a little out of my wheelhouse. But I think there have been over 36 hearings on AI just in the last year or so, and there have been 30 pieces of legislation or thereabouts proposed. Some of it broad, some of it narrow. A lot of the concerns are on one side of the spectrum. You have concerns about making sure that the U.S. maintains its leadership in tech. And so there's a lot of focus on promoting investment, making sure that the market remains competitive, and those sorts of things, so that we can, be a leader in AI. Then there are, on the other side of the balance sheet, there are concerns about misuse of AI, whether it can compromise national security, whether there's adequate disclosure to users, whether whether there are other harms, deep use of deep fakes, those sorts of things. So the legislation's sort of dealing with these two goals, which in some respects could be consistent with each other, aligned, but also could be in tension with each other. I think there are 2 or 3 overarching bipartisan bills, 2 in the Senate, 1 in the House, dealing with AI. The one in the House is kind of punting a little bit. It just says we'll set up a commission and we'll figure it out, deal with it later. There's one in the Senate that does sort of the same thing, but has some guiding principles that they say, well, we have this framework for how to think about it, and we're going to invest resources working on this, and these are the 5 things we're worried about, and the study group should focus on this. And then there's another bill in the Senate that has a little bit of that. I think it's called the one I just described. I think it's called the Safe Innovation Act, and the other one's the Licensing Framework Act or something like that. And the Licensing Framework Act has some principles as well, but also has some specific things like Section 230 won't apply to AI. So there's a lot of noise, a lot of chaos as always, but no real legislation yet. And you know, I'm not the right person to ask whether it's likely whether there's likely to be legislation this year, because that's, as I said, outside my wheelhouse. But.
Yeah, just to mention very briefly, a couple of years ago, the state of New York almost passed a law which have said that the standard for monopolization was abuse of a dominant position, exact standard used in Europe, which would have put, I think, a lot of competitive behavior by the platforms potentially at risk. So there were proposals in Minnesota and some other states along those lines. So again, those cannot be ignored. And there's also, all 50 states have so-called little FTC acts, which apply to unfair methods of competition. In some of these states, what is an unfair method of competition goes beyond what case law relating to the FTC or even settlements have said. So that's something else you need as a counselor to keep track of. And as Barry mentioned, the FTC, in November 2022, the FTC issued a new policy statement saying that behavior that's oppressive or otherwise unfair, that might hurt business, that might hurt all sorts of interests, is unfair. And up to then, the general understanding had been that, well, maybe unfair methods of competition is something where you don't quite have an agreement, or it's hard to prove, or it clearly harms the competitive process, less vigorous competition, doesn't quite fit under the Sherman Act. Now the FTC is saying, well, it goes way beyond that. Now, again, that hasn't been brought up specifically in cases, in litigated cases, but you should at least, as counselors, and just be generally aware of all of these developments.
Thomas. I was just going to say, Barry mentioned there are more targeted bills being introduced, and Senator Klobuchar has been focused on the algorithmic pricing issue and just introduced another bill within the last 6 weeks. I think there were a number of other Democratic co-sponsors. I don't think there were any Republican co-sponsors of that one. So again, I'm not going to predict whether it goes anywhere, but.
I think we have a question.
Okay.
Sir.
And I apologize if it goes too far afield, but you mentioned the unfair practices. So the FTC put out the dark practices report last year, and that focused a lot on the use of AI and other techniques, not at the anti-competitive level, but at the consumer level.
Right.
And I'm just curious as to the extent that you see greater enforcement looking at vertical behavior versus horizontal behavior.
Well, that's an excellent question, and indeed, the FTC, over half of its resources, lawyer enforcement resources, historically were devoted to consumer protection, so-called unfair acts or practices, and unfair or deceptive acts or practices. And clearly, I think the idea that AI may be used not just in cases of pure deception or falsehood, but may be used in subtle ways to cause consumers to behave in a less than optimal way against their best interest without knowing it. That sort of thing, so-called dark practices don't get into, but they say it's sort of subliminal. Some people say just clever advertising, subliminal hints that leads consumers to behave in a certain way. And certainly the people on the consumer protection side, I know the head of that bureau, and is certainly very aggressive in that regard, and I think the chair Khan is. So pay attention to what's written on the consumer protection side. It's of interest.
Yeah, we've been focused on competition, but I think there have been a couple enforcement actions on the consumer protection side involving AI and in particular data collection, where FTC through a consent decree ordered companies to delete location data, for example, and other sort of demographic data on the grounds that like the companies had not adequately disclosed to the consumer. That's what they were doing, and also based on concerns about how the data was being used. So there's actually been more enforcement activity there than on the competition side.
Yes, and a lot of that really does take place through consent agreements too. And certainly in that whole issue of data privacy and in the supposedly inadequate data privacy programs and companies, there were 40 or 50 consent agreements, even though a lack of litigated cases. So that may continue based on litigation risks companies perceive in matters affecting their use of AI. Gene.
I have a question. When you're looking at this stuff from, well, let me take a step back. Yesterday we heard a lot about how these companies that are developing AI tools and products and models get training data and how they use the training data and so forth. We also heard a lot of people say that these companies either they can't or they won't, or there's no way to know what training data was actually even been used with the AI. So I wonder along this thread of, do you have access to the information? Is the information being used the way it was intended to be used? Do you have somebody else's information you're not supposed to have in there? I mean, from a regulatory standpoint, if it doesn't go too far afield from this conversation, how is that going to play out? I mean, how would regulators, like if this were some guy named Bob, because I love that test, because I think on the copyright side, there's things that the developers are saying are not copyright infringement, but if I did them, they'd certainly be copyright infringement, So if some guy named Bob did this, how would regulators go to Bob and say, Bob, you got to tell us what you've done so we can know whether it's okay. And then Bob says, well, I have no way of telling you. I would think that doesn't go over so well.
Yeah, and then clearly in discovery and so on, we'll see in the future there may be, if there are records, about the training data and how it was decided upon. I mean, in the issue of collusion, tacit collusion, for example, you can imagine also what if there's big databases at a trade association for producing some, I don't know, some widgets or whatever, and some of the data is just historic and cost. Some of it, though, has been added. Companies say, we're not going to share it directly with our competitors, but here's how we think about our pricing changes over time and plan to in the future. Well, that's some database at the headquarters is used to train the algorithm. That could raise some very serious anti-competitive problems. So I think it underscores the point that legal counselors need to know something about not they can't all the details, but how is the training being done? Where's the information from? What are potential safeguards? Aaron, you have?
Oh, go ahead.
The only other thing I'd add from the sort of the antitrust point of view, rather than a future AI regulation point of view, is that you also want to keep an eye out for sort of more classical restrictions that could be kind of ancillary to that arrangement. Like you could imagine a company that says, well, if you want to use our AI, you therefore have to give us certain confidential data, right? Which might be, might be efficient, might raise concerns about whether it's exploiting their market dominant position. They might prevent you from working with their competitors, right? Say if you give us AI data, it has to be on an exclusive basis, and you could imagine restraints that are sort of interfering with the sort of competitive operation of the market that are sort of a little bit aside from the black box nature of exactly what goes in and what comes out. And I think those are things you would want to be really conscious of as you're counseling your clients and thinking about it.
And I think that, your question in some respects asks, well, what do I need to do if I don't know what's going on inside the black box? And I think you need to do as much as you can, probably. I mean, there was a speech recently by, I forgot his first name, Tanzi, in Crim 1.
Brian, I think.
Brian Tanzi gave a speech. He's in criminal enforcement at the Antitrust Division. And, he said a number of things with respect to AI, but one of the points he made is, you need to, you can't just be passive and say, well, I didn't know. There's some, obligation to understand the tools that you're using and how they work. He also said that small companies need to pay more attention to this sort of thing than in the past. And the thinking was that AI, even in markets that are not concentrated, because in order to conspire, and he's a criminal lawyer talking, in order to conspire, you usually need, if you have too many actors, it's hard to enforce the conspiracy and it falls apart. And one of the points he made in his speech was AI makes it easier for a broader group of firms to conspire because you can manage the information and better police and all those sorts of things. And so he was, the takeaway was, if you're a small company and you're in a fragmented market, you shouldn't assume that you're okay anymore, because in the old days you were probably okay. Now with AI, it's unclear.
Julie, from the economist's perspective, anything to add on that?
I think just what Aaron said, that like what else is around what are the sort of ancillary agreements that are around it that really speaks to sort of the motivation for the conduct.
Thomas.
There are cases that deal with these issues. I mean, the point that you're raising, Gene, is about the inputs, and there are cases that deal with, if you are a dominant actor in a relevant market, and you lock up all of the inputs, and create barriers to entry to that market, that's an antitrust issue. Antitrust cares about that. Now, sort of strangely, what you're talking about is the reverse, that it's the Wild West and everyone's just going and grabbing inputs left and right and no one has them locked up as of yet. But you can foresee, as was talked about before, as things play out where copyright actually gets enforced and people start licensing data, there will be an issue about if a dominant player starts locking up inputs.
Mm-hmm. So, and then the next question along the same lines that came up yesterday a bit when we were talking about the copyright conversation is what are the burdens going to be? Burden for production and so forth. Like, for example, in the copyright space, if somebody is infringing, you have to say that they copied, right? So you can infer that they did that. If there's a massive amount of similarity, you can infer access. And if there's less similarity, then you need more proof of access. It's kind of a sliding scale. I'm bothered by the fact that a lot of these training sets and the AI folks, they say they can't tell you what is in there, what they used, what the model was fed. And if that's true, how is somebody who's going to want to bring a case, whether we get to the point where you did lock this up? You say, well, prove I locked it up, because I can't tell you what I used. Well, to me, that doesn't. There ought to be something to say, well, I have some good faith belief based on what's coming out here the other end, or based on the fact that my association people can't get agreements, that there is some kind of collusion here going on, or there has been some locking up or whatever. What burdens of persuasion or production are going to need to change or already exist within the framework that might be useful to know about?
Well, so on the civil side, the burden is what you would typically see in a case. I mean, in terms of locking things up, locking up inputs, there would be license agreement. There would be at some point license agreements with some data source, between some data sources as the licensee and then the AI company as the licensor. So you might not identify exactly what that data is, but you would see the nature of the commercial relationship and whether it's exclusive or non-exclusive, whether the licensee has the right to license to others, which is the key issue. That part would come out by whatever the agreements are, whatever the terms of use are in terms of the data. And then, a point that I was gonna raise later, perhaps, was that antitrust litigation is perhaps the most expensive kind of litigation there is. The volume of documents, financial information, communications, all of those things. It has been nearly overwhelming for lawyers, and you're going to go through and you're going to recreate. You're going to reverse engineer, and you're going to go back to the beginning when the data set is getting assembled, and you're going to go back to where it gets transmitted, and you're going to trace through all those things.
So the question, but see, I have more parade of horribles now in my mind about this topic than even before, because it is so easy to collude and not get caught, right? And it seems, so the regulators already have, and the civil folks already have, a lot of hurdles to be able to demonstrate that, oh no, you came to an agreement. No, we talked. We're friends. We know each other. Everybody knows everybody in the industry. But there was a wink, wink, nod, nod. Well, how do you prove that? Well, you go to the next level with this. Like, what if everybody in the price setting, they have these AI to dynamically change prices based on the market demand. What if everybody's using the exact same algorithm and the exact same training data? And they tell you, and I can't tell you what I used and how I used it or what the machine has learned. I mean, it seems to me to be like an enormous risk of just having the entire industry colluding in ways that we would not let the guy named Bob do today. And I hear it already. They're going to say, and there's nothing we just can't possibly tell you what the models are, so we can't unpack it for you.
So I think, Gene, sort of how I think about sort of the setup that you're laying out is that collusion comes down to, is this independently profitable for me to do, or is this only profitable if we're all doing it? And so for me, that's the test that I would have. If I see everybody using the same inputs, having the same output, is that only profitable if they're all doing it? Then that sort of speaks to that there's potentially some collusion happening there. Or is this just competition on the merits? Like, this is in my independent self-interest to use these tools because my competitors are also using these tools, and these might be a way that we achieve lower costs or some other sort of quality outcome that I need to be able to compete effectively with the other firms in the industry. And so I think a lot of this would go back to a lot of the process that Thomas was talking about, some of the things that Aaron was talking about, where there's going to be, if this is really a collusive scheme, right, there's going to be some documentary evidence that will read one way or the other, right? This was independently profitable for me to adopt these tools, and so I have, versus this only makes sense if we all do it.
And I get that, but I guess what I'm getting at right now is, in order to get past a motion to dismiss, you have to have some kind of proffer.
So I don't know. Aaron, I feel like this is exactly what DOJ addressed in Yardy and in Real Page.
It is.
It's a very question.
I mean, we did talk about it for 50 pages or whatever, so I won't capture everything. I would say we're a little spoiled, if you want to look at it this way, on the government side, in that, yes, to get past motion to dismiss, you need a certain amount of evidence, but we can conduct pre-complaint discovery. So when I think about it from what is an enforcement agency going to do? We're going to go looking for those documents and that extrinsic information to help us figure out, well, how should we be thinking about this use of the pricing algorithm in this particular market? How is it being sold to the users? How is it being pitched? What are they talking about when they're talking to each other about whether do they seem to care whether other people are using it or not? Does it work is it advantageous even if people aren't using it? It raises, all of these questions are questions that you can go to the documentary evidence to find. I admit it's a more challenging question when you have, private cases that are obviously don't get discovery before they file their cases, and you got to then figure out, well, is it enough in order to cross that threshold of plausibility that you can, avoid a motion to dismiss? And that's what we talked about at length. But if you think about less sort of just the procedural hurdle at the motion to dismiss stage, I do think, I think these questions are hard, but I think there are answers to them in the specific facts of specific cases.
Didn't DOJ last week say in Yardy that if everybody agrees to use the same algorithm, basically the same training, that agreement to on that is enough to survive a motion to dismiss. I thought.
Yeah,
that
I mean,
was
I
the
think
gist of what you guys
to
said.
me, that's always, I think of that as kind of a little bit of the easy case. That's like only one step removed from you all agreed to fix prices and what your price is going to be. If everyone in an industry like agrees to use the same pricing algorithm, then the whole hard part is like how much evidence is there to infer whether or not they've agreed.
Right.
That's the tricky part, because if they all get together in a room and agree to use a pricing algorithm, you're not talking to me, you're talking to Ryan Tansey, on the criminal side of the house.
And I guess that's where I'm going. I mean, because like I'm generally prefer light-handed regulation. Where necessary. But it seems to me in this particular space, given the fact that the people who might be inclined to challenge these things or see things that they might want to raise in court are not going to be in the position to show up and say, hey, I need to know the following X, Y, and Z. Whereas if DOJ shows up and asks questions, they're going to cooperate. And if they don't cooperate, then that's a different red flag that goes up.
I would tell you a definite red flag I would be looking for is is all of your confidential business information going into this algorithm and being used by other people to set their prices? That should be setting off all kinds of alarms, because that is very different than you have your own set of data and whatever's public, and you agree and you decide to use a pricing algorithm because pricing algorithms are efficient and help you maximize prices. To me, it's
Right.
a very different world if you're using your competitors' information.
Good. Before wrapping up, I'd like to raise one last issue. The issue of innovation, as the international competition is very important. AI has been seen as a potential driver of innovation. One concern has been raised that small startups, you may have, brilliant people come up with new AI-related tools, and they
Let's call them
don't-
ChatGPT.
Yeah, well, I mean, but they were concerned because they don't have the scale, and they don't want to specialize. They want to sell to an established platform. And the concern you sometimes hear is that, well, if it's said that platforms should not be acquiring these small startups, you're going to get it, and I've heard this also from VC people, that happens, you're going to get less investment, less VC investment in these sorts of startups, and you're going to get potentially lower innovation, things that are not seen but never happen because of that. Does anybody have concerns about that, in looking, because there's a lot of talking about killer acquisitions or small, or even newcomer firms shouldn't be acquired by platforms? Well, couldn't that kill a lot of innovation?
I have lots of concerns about that, actually. The United States, as part of its national standards strategy, has identified AI as a technology that's essential for U.S. competitiveness and national security. And leadership by U.S. firms in AI, but in any industry really, can happen through internal growth for sure, but also happens through strategic acquisitions. And so I think to maintain the vibrancy of the AI startup ecosystem, exit through acquisition absolutely needs to continue to be a viable option for startups. And I have a lot of concerns, so this is, Aaron, where we might part ways a little bit. I have a lot of concerns about the new merger guidelines, which set and this is in the weeds for non-antitrust people, right? But that set a more stringent structural presumption for acquisitions. So they introduced this new presumption that acquisitions by a firm with at least 30% market share trip this structural presumption, right? Any acquisition that they're going to do. And a concern I have, and that I've been sharing with people any opportunity I get, is that the antitrust agencies, as far as I know, aren't getting any additional resources, right? So a lot more acquisitions are going to be caught in this stronger structural presumption. And so that makes me question, how are the agencies going to decide which acquisitions they're actually going to pursue for enforcement. And the only answer that I can reasonably come up with, to be quite frank, is that those decisions are going to be likely to be politically driven. And because AI is sort of the new sexy thing, right, I think any AI acquisition is going to get reviewed. And so I feel like this additional scrutiny on AI deals, sort of as Alden has suggested, could really have a chilling effect on startup innovation, which we know is going to have a significant impact on innovation. And like many of the generative AI tools that we're talking about today were in fact developed by startups, and so we want to continue to continue to have a robust startup ecosystem in AI. And then the other thing, this is not about mergers, but that I see coming out of more FTC, so maybe you're off the hook here, than DOJ, is, FTC has been really active in the IP space, where sort of antitrust intersects with IP. And strong IP rights are also hugely important for startups to secure funding, for them to be able to commercialize their investments. I'm sure everybody in this room understands that. But maybe what might not be apparent to everybody is that FTC's been really active around IP rights. So they recently made complaints to the FDA about patents that were improperly declared to the Orange Book. They had this comment to NIST advocating for the use of Marchand rights under by Dole. And both of these things, right, sort of weaken IP rights. And now these are very pharma focused actions by the FTC, but the call for comment by NIST is thinking about spaces much broader than pharma, in which AI related IP could get wrapped up. And so I think sort of these efforts by FTC, or at least apparent efforts, to weaken IP rights, combined with some of this, more stringent merger enforcement, really to me is at odds with the thriving startup ecosystem in AI, and then also with sort of the larger administration goal, right, to really be promoting U.S. leadership in AI. So I think there's lots of things to be concerned about here.
Anyone want to respond?
I suppose I should respond. The only observation I'll make is that I feel like we started this panel with the notion that there have been, I believe, no merger enforcement cases in the AI space, and so to me it's a huge leap to the idea that merger enforcement is set at such a stringent level that it's deterring innovation and deterring the development of companies. I mean, when I feel like, the ability of small companies to exit by selling to people in the industry is obviously efficient overall for the economy, but I feel like when we're talking about these kinds of concerns that come up, usually that's one or two companies that trigger that concern for any particular buyer. I mean, for any particular startup, and doesn't in any way, shape, or form foreclose the idea that there are other people with complementary products that might be able to acquire them. It means they might not be able to be acquired by the company whose dominance they're most threatening. Like, okay, I'm willing to live with that.
Yeah, I guess to get a little bit more in the weeds of this, though, right? There's a difference between sort of what I'll call disruptive innovation versus follow-on innovation, and at least the actions I've seen, maybe more out of FTC than DOJ, is like, yes, I'd be concerned too, right? If this is sort of the killer acquisition story, right? You're sort of buying the company that's going to displace you in the marketplace. But I think that's not what we're seeing in terms of merger challenges, right? You think about Meta Within, right? That was this sort of potential competition case where I don't really think Within was going to be sort of the company that displaced Meta, right? And so I do think that has sort of sends a message, right? That exit through acquisition is going to be more challenging, and I think that's not the message that we want to be sending to the AI startup ecosystem right now.
Question.
So I hear you talking a lot about this, and I think that there's actually real data that goes against some of what's been said on this panel, because Series B, Series C, Series D venture capital money has decreased substantially in the last couple of years. Some of that because of the peak that happened in 2021, but that deals like not necessarily in AI, but the Adobe Figma merger went down, the Amazon iRobot merger went down because of antitrust concerns, either abroad or domestically. And so I think that from what I've heard from venture capitalists in this space, particularly in the middle market, not necessarily at the siege stage, but where they're getting ready for mergers, there's definitely been some market pressures because of the things that we're talking about. And so I'm curious as to whether there's been thought about that from either the FTC or the DOJ, and whether like that's been part of these concerns, because there could be consumer harms related to these innovations not getting the funding to get them really to that last stage, or whether there's going to be not necessarily a collapse, but harder ability to raise capital for those companies.
I would love to hear if DOJ and FTC are thinking about that as well.
It's very hard because when you're as an enforcer, when you take the facts of a particular case, be it like Adobe Figma, I've been a long time working on that case. I think I can say here our investigations is public in that respect. It's very hard to try to factor in the effect on the overall ecosystem for enforcement when, as a antitrust enforcer, looking at the facts of a particular case. So it's a fair question when you're asking about like the policies, that are set in the merger guidelines or wherever, and I know those are factors that they absolutely think about. We've got brilliant economists, and many of them who are thinking about these very questions. I like to stick a little bit to my law enforcement lane and my looking at I got cases in front of me and deciding whether or not they're going to harm competition or not, whether we should recommend enforcement action. So it's not an unfair question, but I'm still going to duck it.
I'll just add one last thing. I think there's a footnote in our primer on AI and antitrust, and there are a couple of studies. It's also in an article I'm writing with Professor Dan Spolver that sheds a lot of doubt on these killer acquisition stories. There was a major article written in 2019 about killer acquisitions in pharma, and then some people picked it up and said, oh, this is a big problem. I think there's a lot of evidence that shows it's not a big problem. It shouldn't be a big concern. I'll just leave it at that. I know we're running late,
yeah.
But anything else, Gene, or any closing comments?
I think we're good. I really appreciate that. That was an excellent conversation. I'm worried, but we'll see how it all plays out. So, thank you all.
Thank you.
Thank you.
Okay.